Welcome, everybody. As mentioned, my name is Jennifer Jensen. I am the Information Management Coordinator for Tsawwassen First Nation, and I'm going to talk about our Freedom of Information and Protection of Privacy Act and some of the associated legislation that goes along with that. I do tend to talk fast normally, and we have a lot to cover, so I'm going to kind of fly through some of these slides, and hopefully we can have time at the end to address anybody's questions. So Mitsep Kokwelam, welcome. I'm just want to start by acknowledging that I'm coming to you from Tsawwassen First Nation territory and the traditional territory of several Coast Salish nations, including TFN. And just a little bit about me, I graduated from the UBC iSchool in 2003 with a Master of Archival Studies degree and with the First Nations curriculum concentration from that program. And in over the last, prior to coming to TFN, I worked in records management in various levels of government and archives as well. And I also worked as a researcher for the federal government, the residential schools resolution claims process. So for the IAP and CEP claims, I was part of the research team for that. I started working with TFN in 2010. And I also just want to clarify, I'm not a member of TFN. And I'm also not an Indigenous person. My ancestors were settlers here, and but I've learned a lot in my 12 plus years of working for TFN. So a little bit about TFN for those of you who may not be familiar. We have just over 500 members. I think it's like 510 now, and about half of them live on lands. And the other half live in various locations. They live in the Lower Mainland and in the Okanagan. We have some members in the Okanagan. We have some members in Thunder Bay and Winnipeg, and about 100 members who live in the US. Some of them are American citizens and some are just our residents. And that's mostly in the Bellingham, Washington area. And a lot of our members have family ties to nations in Vancouver Island and in Washington State, so Tulalip, Lummi, Swinomish, other tribes in the U.S. Under treaty, so we do have a young population. About half of them are under 30, and the land base is 724 hectares post treaty. That is about double the size of what the land base was before, and so it includes the former reserve lands and then also the lands that were acquired as part of the treaty. There's quite a lot of development going on right now, and currently we have about 2,000 non-member leaseholder residents on Tsawwassen lands. They live in so this is a commercial lands area here. This is our mall, and the residential leasehold development area is all kind of in here. This photo is a few years old. So this area is quite substantially built up now. At full build out, we anticipate that the leaseholder community will be about 8,000 to 10,000 people. That should happen in about over the next 10 years or so. Okay, so the treaty came into effect on April 3rd, 2009, and it was the first treaty that was completed under the BCTC 6-stage treaty process, and there have been others that have been completed since then. It uses a concurrent law model, which I'll talk a little bit about later. They're somewhat complex, but basically the purpose of a concurrent law model is to make sure that there's no legal vacuum. And there were 23 laws that came into effect on the effective date, April 3rd, 2009, including FIPA. However, FIPA was delayed. Coming into force of FIPA was delayed till January of 2010 because they wanted time to develop processes to actually respond to access to information requests. There was some concern that there would be a flood of access to information requests on April 4th, 2009. So they wanted to give staff time to create process to deal with it. The elected government, it consists of 13 legislators plus the chief that are elected. Previously, the elections were every 3 years, and now the Election Act was just changed, so now they're every 4 years, and they line up with the local with like local government elections, municipal elections. So our next election is going to be this October, on the same day as all the municipal elections. The legislature normally sits twice a year. Sometimes there's an additional session, the spring session, which runs in February, March, and the fall session, which runs usually October and November. Among the legislators, the four legislators who receive the highest number of votes plus the chief, together those 5 people make up the executive council. And so the role of the legislator is usually to approve legislation, and that includes the Appropriations Act, which sets the annual budget. And the legislature follows the process usually follows pretty closely follows the Canadian parliamentary process. So we have 3 readings. We have a bill, introduce a bill, and we have 3 readings, and then they vote on it. But there are a number of Tsawwassen cultural elements that have been incorporated into the sitting. So, for example, we use a talking feather, so you can only speak if you have the talking feather. Legislators, when they meet, they're drummed in and drummed out of meetings. So there are cultural elements incorporated in that as well. For the Executive Council, they meet weekly, and their role is to work with the CAO to oversee more of the day-to-day operational needs of the government and provide strategic direction. And they also give approval to sort of major initiatives, major decisions, high-value contracts, and they enact regulations and policies. We do have some other elected bodies. The Advisory Council is a forum for where members can bring their feedback and sort of acts as sort of the voice of members to elected leadership. And then we also have a few committees that are elected committees that are sort of more focused on specific issues. We also have some appointed bodies, including the Judicial Council, which hears complaints or disputes relating to Tsawwassen laws or about administrative decisions. They're sort of a court for Tsawwassen laws. And then Standing Committee on Language and Culture is appointed by the legislature. The Leaseholder Consultation Committee currently is an appointed body, but we're now at the point where we have to start doing some work to figure out what that body is going to look like in a more formal way. It's kind of an ad hoc body right now. And same with the Property Tax Authority. So currently those bodies are somewhat sort of ad hoc of just people who want to participate can participate, but over the coming year or so, we're going to have to formalize that a bit more. We have the Enrollment Committee that deals with applications for enrollment, and then a trust society to manage the trusts that are set up by the Tsawwassen government. And this isn't an exhaustive list of all of the entities, but because we also have corporate entities and some other entities, but it gives you some sense of the structure of the government. Our administration, there we all are on Orange Shirt Day in 2019. We're slowly starting to come back into the office. There's about 120 staff, actually, I think maybe a bit more now. Yeah, I mean, sort of you can see the list of departments there is kind of what you would sort of normally expect in a small local government. And yeah. So FIPA legislation, why do we have FIPA legislation? Well, one reason is because we have to. Under the treaty, we are required to have access to information legislation, and specifically under Chapter 16, Clause 45. So as mentioned, we had the FIPA legislation that was enacted in 2009 and came into force in 2010. We also have the regulation. The regulation sets out the process for making an access to information request, and it also, the schedule to the regulation is the form that people should use. If you've ever looked at the federal government's ATIP form, you'll probably notice that it looks really, really, really similar to the one that we use. And then in 2014, we had to amend FIPA because there was a question that came up around whether or not we could use photos that the government takes at events in publications from a privacy perspective. And we got a legal opinion on it, and the legal opinion came back with actually, we're not sure that you have the authority to take the photos at all. So we amended FIPPA, and the language, we added language that is also very similar to language that exists in the BC provincial legislation, saying that TFN has the authority to take to gather, because person's image is considered personal information. So we have authority to collect that information in photographs, or by observation is the legal term. So we can collect photographs and we can use those photographs for official purposes. So that was the purpose of that amendment. And now that we've had some years with this act and the process and seeing how it all works, we're starting to look at how the act might need to be amended, and the regulation as well. So staff and TFN as a government, like all governments, have a right. Citizens have a right of access, or people have a right of access to information, and the government has a duty of care to take care of that information. So under our legislation, any member can make an access to information request. If you're a non-member, then you have to be a qualifying person in order to make an access to information request, and that is defined as a person, and I'm reading here just so I haven't memorized this, whom the Chief Administrative Officer determines to be directly and significantly affected by information contained in a record or in the custody or under the control of a TWASN institution. So basically, it's up to the CAO to decide if somebody meets the definition of a qualifying person. But anybody who wants their own personal information, it doesn't matter if you're a member or non-member, you have the right to access your own personal information. And then TWASN institutions have a legislative duty to protect personal information that they collect from unauthorized disclosure, and unauthorized use, access, collection, et cetera, and disposal. So a TWASN institution is defined in the treaty, and it includes the TWASN government or a TWASN public institution. And under the treaty, TFN has the power to establish TWASN public institutions, but there's not currently a lot of clarity around how you actually declare something to be a TWASN public institution. So sometimes that leads to there's some questions in some cases around whether or not something is or is not a public institution, because there isn't actually any sort of spelled out process for saying this is or is not a TWASN public institution. So access to information requests, as mentioned, the process is in the regulation, and it's modeled very much on the federal process. We have a 45-day timeline from the receipt of application, but it's possible there are some possibilities for extending that deadline if needed. There are some kinds of records that are excluded from FIPPA. So for FOI requests, we are not required to provide anything that was created prior to April 3rd, 2009, because the sort of jurisdictional authority over those records was different before the treaty came into effect. Personal information requests, though, it does go back prior to April 3rd, 2009. Records of elected officials are exempt. So if somebody makes an access to information request, we would not, and for executive council minutes, that's one of the most common ones, we would provide TFN has staff have copies of the executive council minutes that we keep as the official records. That's what we would use, but we would not go to a member of executive council and say, you need to provide your emails and your access or your copies of reports, because as an elected official, their records are exempt. Sometimes we have the same records they have, so our copy does fall under FIPPA, but their copy doesn't. There are also instances where staff are creating records where the jurisdiction is actually they're not records that fall under TFN's jurisdiction. And the main example of that is when we're doing IRA activity. So Indian Registry Administrators are the people who they do status cards and they help people apply for registration under the Indian Act. And they're basically the liaison between the membership and the federal government, the Department of Indigenous Services Canada now. when we do those activities, we're actually acting as an agent of the federal government in those when we do that specific work. So those records actually fall under the federal government's jurisdiction. And in order to get access to those records, you'd have to go through the federal government process, not through TFN, to do that. As there are a number of exceptions to the disclosure, and those are in section 13 of the Act. So there are two instances where we must refuse to disclose, and those are where if disclosure would cause harm to financial or business interests of a third party, or if disclosure would invade somebody's privacy. And then there are another suite of exceptions that where we may refuse to disclose. So we don't necessarily have to refuse, and sometimes there may be reasons why we would want to, even if disclose the information, even if it does fall under one of these exceptions. The main theme of all of the exceptions is the harm that would be caused. So the way you approach looking at the records is to assume that the information is disclosable unless you can apply an exception. And when you're looking at harm, it also has to be some kind of specific, it has to be like specific harms. It can't just be like perhaps maybe it might cause harm, some unspecified harm at some point. It has to be like a sort of a specific definable harm that you can identify. And the reason for that is because if somebody challenges our withholding of information for an FOI request, we have to be able to defend that. And so we have to know why it is that we chose not to disclose something, or how that particular exception to disclosure applies. So a lot of these exceptions are also similar to provincial legislation, but there are some that are a little different. So, and one of those is the harm the spiritual cultural practices of TFN. So an example of that is we have some oral history tapes that were made during the treaty negotiation process. They were part of a traditional use study, and there are elders who gave us a lot of information about traditional use of plants and traditional use of different areas in the Lower Mainland, and did that as part of the study. These studies that were part of the treaty negotiation process, and many of those elders have since passed away. There are cultural protocols around who can hear certain kinds of cultural information, cultural knowledge, and who that can be passed on to. And for us to simply give it to anybody who asks for it would be really disrespectful. Those elders who spoke to us, they did so for really specific reasons, and gave us something that was the knowledge that was very meaningful. So it would be really disrespectful to just kind of hand it out. So you can't make an FOI request for that information. We would evaluate, like we would look at that and say, if we disclose this information publicly, that would cause harm to TFN's cultural practices. So we would be able to refuse to disclose. One of the things that I do tend to remind staff about when I've done this presentation for staff, is that one of the things you won't find on this list is we cannot refuse to disclose because of personal embarrassment. So if disclosure of a record would just make you look bad, that by itself is not a reason to withhold a record. So just something to keep in mind if you're going to, when you're putting things down in writing, or you capturing things in email or whatever, like just kind of bear in mind that there's always a chance that it might be disclosed. So yeah. So what does it mean for staff? That it means all records, which are paper and electronic records that are in custody or under the control of a Tsawwassen institution, are FOIable or subject to FIPA. That does not necessarily mean they would be released. It just means that if any record that falls under the scope of a request has to be reviewed, so that we can make a judgment call. We can judge whether or not it should be released. And record includes any recorded information, so that is created for work purposes. So that, the obvious ones: documents, maps, emails, etc. Text messages are considered, if they're work related, they're work product, they're records. I've never actually been faced with having to figure out from a technological perspective how to disclose text messages, because then that involves getting into like proprietary like technology. But in theory, it could happen. Audio and video, those are all FOIable. So our phone system, for example, when somebody leaves a voicemail on our phone system, it sends an email, like a file, an email file, a little WAV file with a voicemail and email. That's a record. That's FOIable. So any recorded information would be considered a record. If staff if they're asked to provide records, what I tell them is like, make sure you provide anything that you think is relevant. Do not edit anything. And if you're not sure, just include it, and we'll screen it out if it's not relevant. FOI requests aren't always needed. So we do have routinely releasable documents. So basically anything that's published, anything that is widely distributed to members or to the public, the information that's on the website, all that kind of stuff. You don't need to make an FOI request for that. We can just hand that stuff over. Same thing if we have documents that are publicly available elsewhere, it's not necessary to make an FOI. If we have a copy of a report that's on the provincial government's website, for example, we can provide that to people. They don't have to make an FOI request. We probably would just tell them to get it from the province, but if people are requesting information about themselves, or if they're making copies, just information, not their records, but just like discrete pieces of information about themselves, or if they're asking for copies of documents that they themselves authored, we can provide that. So often I get people calling me asking me for their status number, which we can disclose. We can give somebody their status number. I usually just ask them their birth date to make sure it's the right person. Or like, I'm getting, how much of an honorarium I'm getting, that kind of information, where you're just giving them a piece of information. That's fine. It does get a little complicated though if you start talking about things like application forms, like if they're applying for a grant. If it's just the information that they have provided, we could give them a copy of that application form. But when you get to the point where there's sort of evaluative comments from staff on like why we approved or didn't approve this grant, then you get into a gray area, but it's not quite so straightforward whether or not you can provide them that record. If somebody asks a question, then you can answer without giving them any documents. What is their official position on XYZ project? There's no FOI request required for that. But at the same time, the sort of confidentiality and the exceptions to disclosure, those things still apply to verbal information too. So you wouldn't want to say things that you wouldn't give to people in writing. And government to government information sharing is also exempt. So when we give something to another government, that they have, other governments have their own umbrella of privacy and information protection. And so when we share information, the expectation is that the provincial government is going to protect the information the same way we would, because they have their own legislation that mandates that it would be protected. So it's not the same thing as disclosing publicly. The purpose of an FOI request is to make the information public. When we're sharing it with another government, we're not making it public. If it's particularly sensitive information, or then you can start getting into things like non-disclosure agreements and whatnot. But generally speaking, information sharing with other governments is okay. So protection of privacy. That means that we have to have informed consent in order to collect the information. We have to tell people why we're collecting their information. We can only use that information for the purpose for which it was collected, or a consistent use. We are limited in what we can disclose, how we can disclose by Section 24 of the Act. In a small community, though, this can be a learning experience, and there are expectations of convenience or helpfulness that can kind of butt up against our legal responsibilities to protect people's privacy. Sometimes members, they want to know information about their families, or they want to help a family member. They come to us and say, I want, my brother needs his copy of his information. And we have to, we're trying to create a culture of privacy protection so that we don't make exceptions for little things, because exceptions for little things can mushroom into exceptions for bigger and bigger and bigger things, and then you're kind of heading down a slippery slope there. So we're trying to make sure that we are always mindful of our need to protect people's privacy. And even if the person in front of me is like, I know who you are, I know that you're related to the person you're talking about, I know that you're not going to do anything nefarious with this information, I still can't give it to you because it's not your information, it's their information, and they have to come and ask for it. So that can be frustrating sometimes because it's seen as not helpful, but it's our responsibility to sort of cultivate that. So when staff are collecting personal information, they have to make sure that they're only collecting what they need, and that they're informing people why they're collecting it and how that information will be used. And they have to take precautions to make sure it doesn't get disclosed in an unauthorized way. And then there's some obligations around, if you believe unauthorized access has occurred, you have to inform the CAO. You can't share personal information among staff unless it's actually necessary. So just like with members, we're trying to cultivate a culture of privacy. We're trying to do the same thing among staff internally. So trying to make sure people are careful about how much information they share, but we don't want to do it to the point where we're actually hindering people from doing their jobs. So we can share information internally. We're just trying to make sure that people are mindful about it, and that they're asking those questions. If somebody's asking you for something, we're kind of clarifying, like, what are you using this information for? Why do you need it? And what specific information do you need, so that we're not giving them more information than they need. And as a best practice, usually the more sensitive the information is, the more protective measures you need to protect that information. So, accidentally disclosing somebody's name and address is, it's a little dicey, but when you're accidentally disclosing somebody's medical history or their financial history, that's at a different level. So you have to also scale your privacy protection to the sensitivity and the amount of information. And this is also a reason why it can be, the idea of having like one system that has all the information about everybody's information about everything related to their lives, that can actually be a security risk, because if you have systems where you can access all information from one entry point, then that makes it easier for people to find out more information if they can get unauthorized access. Whereas if you segment the information, then it protects it more. Okay, so I mentioned the concurrent law model. I don't want to get too in-depth into how concurrent law models work because they're really complicated. But as mentioned, this it means that there are layers of legislation in effect, and the provincial and federal laws work alongside TWASN laws. The treaty is the document that governs where TFN has authority to draw, or where TFN can draw down lawmaking authority. And the treaty also sets out where TWASN laws, or which laws have primacy in the event of a conflict between TWASN laws and the laws of another jurisdiction. So for FOI, if there is a conflict between TWASN law and provincial or federal legislation, TWASN law will prevail for FOI legislation, but for privacy protection, provincial law will prevail for if there's a conflict. And where where TWASN laws are silent, then the relevant provincial and federal legislation can fill in those gaps. So speaking of, so I can only really speak about the BC. I know there's people here from other provinces, so I can talk about BC. Most provinces, their legislation is fairly similar. But so for BC, we have there's two pieces of provincial legislation. One is FOIPA, and it applies to all of the records that are in the custody or under the control of a provincial or local public body. So when you first look at it, it looks like that this could maybe apply to First Nations governments. But when you drill down through the definition, so the definition of local public body includes a local government body. And then when you drill down to Schedule 1, where it defines what a local government body is, it has this whole list of local government bodies. But for Indigenous governments are not part of that list. So in order for this legislation to apply to Indigenous governments, they would have to amend Schedule 1 of the Act to specify that. And they have not done that. I'm not sure that they will do that. So so the Freedom of Information and Protection of BC FOIPA doesn't apply. BC PIPA, on the other hand, which is the Personal Information Protection Act, it applies to any organization that does not fall under FOIPA. So it does apply to TFN, but in our case, our FIPA is actually stronger than BC PIPA. So our FIPA takes precedence over BC PIPA. But if there was a conflict between our legislation and BC PIPA, then BC PIPA would have primacy. And there are other bodies, so there are corporate entities, for example, that TFN has set up. PIPA does apply to those because those entities are not TWASN institutions. So we have some joint venture entities, for example, that those entities are subject to BC PIPA. On the federal side, we have the Access to Information Act and the Privacy Act. And these apply to records that are under the control of a government institution. So again, this would be ministries of the federal government, crown corporations. Doesn't apply. And I also preface this, I'm not a lawyer, so if there are lawyers out there who disagree, please chime in. But based on our understanding of the act, it doesn't apply to self-governing Indigenous governments that don't operate under the Indian Act because they can't be considered a federal government body. I have been asked about banned governments, so bands that do operate under the Indian Act, and my interpretation of the legislation is that if you were going to say that the federal legislation applies to a band, you'd have to argue that either the band is part of the department or that the records of the band are under the control of the department. And I'm not sure that either body would want to make that argument. So I don't know but it's kind of an open question. It's open to interpretation. So, so the other piece of federal legislation is PIPEDA, which is the Personal Information Protection and Electronic Documents Act. And it, again, applies to all organizations. And in particular, it applies to personal information collected by organizations that are engaged in a federal work or undertaking. So that starts to get into a gray area of whether this can apply to Indigenous governments. Again, I would think that for self-governing nations, they're not operating under the Indian Act. That if they're not operating under the Indian Act, they couldn't be considered a federal undertaking. But for example, if TFN were to set up a corporate entity that is engaged in a federal undertaking, if TFN set up a bank, banks are federally regulated, so banks would fall under PIPEDA. So that kind of entity could fall under PIPEDA. And for band councils, it's kind of hard to say. But at the end of the day, what matters is that what you're required to do is kind of the same across the board. So it doesn't, as long as you're engaging in those best practices around protection of personal information, it doesn't really matter if it's provincial legislation or federal legislation that applies, because it basically requires you to do the same thing. So as long as you're sort of meeting that level of those best practices, you're more or less you're good no matter what. And if and the question of like which law applies, it becomes kind of academic at that point. Okay, so some of the challenges that we've had, as I talked about, like raising awareness among people about what their rights are and what our responsibilities are under FIPPA. Helping people understand why we can't just give them information they ask for, and when they do want information, what they can ask for and how they can go about asking for that. And then also helping staff understand, to be mindful when somebody asks for information, like asking the question, is this something that I can give out? If you're not sure, you can ask me and we can talk about it. But just asking the question, like just the mindfulness of thinking about whether or not is this something that is appropriate to give out, and if I'm not sure if it's appropriate, who should I ask in order to determine that. Whether or not I touched a little bit on before on whether or not something is or is not a public institution. So that question has come up a few times with some of the corporate entities that we've established. Is it a public institution? We're not. The answer at the time was no, it's not. so we didn't include it in any FOI request, but we don't really have there isn't a lot of clarity around how something becomes a TWAS and public institution, or is designated a public institution or not. Some of the there are still some questions around certain kinds of records. One being foster care files is where does TFN's authority to provide that information to people end, and where does the provincial or federal government's authority begin? These are questions that we'll probably not get any answers on until it's actually we're faced with, somebody is asking for their foster care records, and we need to decide who can give what to whom. But until we get to that kind of it's an emergency point, I don't know that we will have any kind of firm decisions on those things. We have had instances where we've had the same person has made a request. They've made the same FOI request to TFN and to the provincial government, and we had to coordinate with the provincial government because we had some of the same records. So we had copies of reports that we had sent to the provincial government. In this case, it was MOTI, and it was about traffic studies. So the provincial government, their concern was, we just want to make sure that your redactions match our redactions. The problem was that they redacted stuff that we would never have redacted. They released stuff that we probably wouldn't have released. So it was a bit, yeah. But that was, it kind of raised that question of if when we have these overlapping requests, if people are requesting the same information or the same documents from two different bodies, how do we coordinate that? Information sharing can also be, there can be questions about, and we've had issues with, particularly with Delta PD. We have the local police here. They're governed by provincial access to FOI and privacy legislation, and our legislation allowed us to share information with them, but there were some questions about whether they could share information with us, and it was related to a law enforcement matter. So one of the things that we've done to try and address that is when we have service agreements with these bodies, we actually are started incorporating language about information sharing to make sure that's covered off, and so there's clarity about who can share what and that kind of thing. And one of the other things that comes up is that which with the traffic study was the because I'm the one who ends up doing reviewing all of the records to try and determine if things are if there's an exception to disclosure or not. I don't know everything about everything. And sometimes I get records, I'm faced with records, and the traffic study was one of these examples. I don't know nothing about traffic studies. And I'm trying to read these reports and decide, is this stuff confidential? There's like graphs and all these math equations about how they did their sampling rates and all this stuff. I don't know if any of this stuff is confidential. I don't know anything about this. So I have to rely on staff to walk me through, like, what is this? What am I looking at? Is this confidential? What is the potential consequences of releasing this information, if any? And that takes not only my time, also takes their time. So just the resourcing to be able to respond to some of these requests can be daunting. So hindsight, one of the issues that I've identified, I don't know if anybody else cares about it, but I've identified it, is in our legislation, there's no expiration for privacy protection. Provincial legislation does have it, like at some point, your information becomes so old that it becomes public information. It's no longer protected. Our legislation does not have that expiration date, and it probably should. Personal information requests are treated the same as an FOI request. There's no distinction. They're both considered access to information requests, but they probably should be distinct because the criteria are a little different. So they should probably be distinct. We don't make a distinction between stuff that's public for members versus public for the public. From an FOI perspective, if it's released broadly to members, that is considered public because it is outside the bubble of the TFN government. Some people, there is arguments on both sides about whether or not we should have a different category of public for members versus public for the public or not. There's arguments on both sides, but I mean, in my mind, the main thing is that once you release it, whether you release it just to members or whether you give it to the general public, once you've released that, you have no control over what people do with it. So that's the, you have to kind of be prepared that it's going to be public. The legislation doesn't address things like data residency, software as a service models of business, that's the way the technology industry is going. And so we need to start thinking about those questions and start addressing some of those questions. It's we're working with we're trying to apply legislation in a digital world where that legislation, the language of that legislation was drafted based on everything being on paper and records being like pieces of paper that you kept in a filing cabinet. So as the pace of change in the technology sphere is much faster than the pace of change in the legal language that applies to this. So you can end up, we have ended up in situations where we don't actually have an answer, like we don't know how to apply certain things because it doesn't translate well to a technology world. So some of the things that we're going to be doing, that we're working on moving forward, was we've got a membership database in works, and it's modular. It has modules for other things. So we're trying to expand that to make sharing of member information more efficient and more secure, because then you have like logins and audit trails and various things. We've also got a content management tool. We've just purchased it, and we're going to be looking at implementing that. And one of the things that it has is an e-discovery search tool, which will allow us to be more efficient in the way that we search for things for FOI requests. And we may also look at expanding this into email as well. And we've also, I've discussed it with the IT team. We've talked about doing potentially developing a privacy impact assessment process for TFN. There is BC has a provincial privacy impact assessment process that applies to provincial government entities. It's quite in depth. It's probably overkill for what we would do, but we've looked at maybe adapting that so that we can use that as a way to evaluate new initiatives and new technologies. So that's a lot to throw at you. Thank you for listening.